So the first thing that we do when we have a client who is arrested for possession of illegal drugs is determine if there was anything that happened during their arrest that we can use to suppress all the evidence that the law enforcement officer found in the possession of our client. So that's a long way of saying, did the officer make any mistakes during the arrest that could lead to the drugs being suppressed and thus getting the case dismissed? 99% of the time, drug possession cases start with someone getting pulled over for a traffic stop and the drugs either being found on their person or in their vehicle. So the first thing we're going to look at is, did that officer have a legitimate reason for stopping your car in the first place? If they did not, so for instance, if they say they pulled you over for not using your turn signal, but we watched the dashboard camera from the squad car and we find that you did in fact use your turn signal effectively, well then we can argue that the officer pulled you over for an illegitimate reason, and it doesn't matter what they found on your person or in your vehicle after that, because the stop itself was illegal. So the search subsequent to the stop is also illegal. We're also going to be looking into whether or not the drugs themselves were tested properly at the forensics lab. We're going to be asking the state to give us access to that evidence so that we can weigh it ourselves. We're not taking for granted that the state weighed the narcotics properly. For instance, oftentimes, if there's a container that the drugs were found in, the state will try to weigh the entire container and the contents of the container and use the weight of the container against you to enhance the charges against you. So these are a lot of sneaky things, tricks that law enforcement and the prosecutor's office tries to use to make your case worse, that we're going to double check and fight if we find out that they were done incorrectly. Let's just assume, for the sake of argument though, that the stop was legitimate, there's no issues with an illegal search, and the drugs that they found on you in fact were illegal narcotics. And so they do have a case and they do have enough evidence to convict you if they wanted to. What do we do then? Well, our job at that point is to mitigate the damage against our client and work out a negotiated plea bargain with the prosecutor's office to avoid the most extreme consequences of a drug charge. So if it was a felony amount of marijuana or other narcotics, our primary goal is to convince the prosecutor's office to reduce the charges voluntarily from a felony down to a misdemeanor. At all costs, we want to avoid felony convictions on our client's record. Generally speaking, if this is a first-time offense for our client, we are very successful at convincing the prosecutor's office to reduce charges from a felony to a misdemeanor at the very least. Obviously, if our client has a lengthy criminal history and this isn't their first run-in with law enforcement, state may be unwilling to voluntarily reduce, in which case our next goal is to at least keep our client from going to prison. Even if they're going to end up with a felony conviction, we want to make sure that we limit the exposure that our client could be facing with prison time as much as possible. Again, most of the time, the relationships that we've built with the prosecutor's office are strong enough that we can convince them to offer our client a deal for probation or potentially even deferred probation, which would ultimately end with our client not having the felony conviction.